have this on a yearly basis.
Not everyone jump up at one time.
Is there,
You can have my seat.
nominations for chair and nominations for vice chair and nominations for secretary?
I'll make it quick. Can we nominate all three of you to stay where you are?
Is there a second?
Second.
All in favor?
Aye.
Opposed? Congratulations, everybody.
Congratulations, everyone.
Okay, now, next item.
Next item would be approval of minutes. And
The-
go ahead.
The voting members on this will be, oh, I'm sorry. This is out of order here. First of all, second of all, I'd like to have the members introduce themselves, starting with my far right.
Andrew Howe, alternate.
John Posey, Commissioner. Roland Lawrenger, Commissioner.
Marie Chassie, Commissioner.
And on my far right.
Robert Flanagan, City Planner.
Paul Stronderman, City Engineer.
David White, alternate. John Sewers, Vice Chairman.
Bill Leeds, chairman. The voting members on the minutes of the previous session will be Commissioner Chassie, Commissioner Soares, Commissioner Howe, Commissioner Posey, and myself. Members had a chance to review the minutes on the regular meeting on December 28th. Motion would be in order.
Motion to approve.
Is there a second? And then there's a second. Any discussion?
Second.
None, all in favor?
Aye.
Opposed? Motion carries. Next.
We move on to public hearings. There are none. Our next item is pending applications. There are none. We move on to new applications. We have application 399, site plan for retail store, motor vehicle parts and supplies, 384 Farmington Avenue, Assessor's Map 37, Lot 48, BG, General Business Zone. Adam Herbert, Casco, the applicant.
Mr. Chairman, again, Robert Flanagan, City Planner for the record. Application 399 comes to us this evening from O'Reilly Auto Parts. Casco is filing the application on their behalf. James Dean of Dean Associates is in the audience this evening. He's the architect representing the application for the applicant. I've conveyed to the applicant that it is staff's recommendation that this particular application go to public hearing. I don't know if you want to entertain Mr. Dean for a minute or two, if he wants to get up and just say a word about the application. He came all the way from Boston to be with you this evening, so.
I'll let him speak, yes. Just state your name and address for the record, please.
Thank you. My name is Jim Dean, or James Dean. My address is 12 Reserve Street, Malden, Massachusetts. I'm the principal of Dean Associates Architects out of Lynnfield, Massachusetts.
Okay. So briefly describe what this application is about, please.
Yes, sir. We're planning on expanding the existing building. The existing building is about 5,500 square feet. We'd like to add on about 4,000 square feet and expand the parking lot as well to accommodate that building. The use of the building will be for an auto parts store, not a repair service. No repairs will take place on the premises. And O'Reilly's Auto Parts does not sell tires, which I know is sometimes an issue. It's parts only for retail for do-it-yourselfers. And we've been in contact with the planning commissioner and going over his comments on the plans and starting to work through some of those as we go. So I'm certainly eager to hear your comments and questions.
Okay.
So, Mr. Chairman, in the packet, excuse me, Mr. Chairman, through you, there was 41 items that came up. So in the next month, it'll be a very, very productive month. We'll work with Mr. Dean's office and his corporate entities to satisfy hopefully most of these comments, and we'll be down to housekeeping when you convene next month for the public hearing. I just wanted to mention to Mr. Dean also that we'll be communicating with you if the board so chooses to call a public hearing on this. We'll be communicating with your office via letter and email about the posting of the signs.
So a motion would be in order to put this on next month's agenda as a public hearing. Motion would be in order.
Mr. Chairman, I move that application 399, site plan for retail store, 384 Farmington Avenue, assessors map 37, lot 48, BG General Business Zone. Adam Herberg, applicant, be on the agenda of Wednesday, February 22, 2017, for a public hearing.
Okay, motion was made and seconded. Motion was made. Is there a second?
Second.
Okay, before we have any discussion, Commissioner Howe just reminded me that I did not say who the voting members were tonight. So there will be the 5 regular members, Commissioner Posey, Commissioner LaRanger, Commissioner Chassie, Commissioner Soares, and myself. Okay. Any further discussion? All in favor?
Aye.
Opposed? Motion carries. And as Mr. Commissioner Soares indicated, our next regular meeting will be Wednesday, February 22nd, 2017. Next.
Next item would be zoning commission referrals. There are none. We move on to city council and other referrals. There are none. Next item is old business.
Okay, I have 2 items that I'd like to present to the commission tonight. And as long as we approve of this, these 2 memorandums will be read into the record. One is a memorandum to Tom Conlon, the Assistant Corporate Counsel from Robert Flanagan. And basically, these 2 memorandums are in reference to having public comments at our planning commission meeting. So the first one is, as I indicated, Attorney Conlon from Robert Flanagan. Can that be read into the record? Yes? Yes?
Yes.
Yes, yes, yes. Okay. Mr. Flanagan, would you read it, please?
Sure. Thank you, Mr. Chairman. Sent a memo to Assistant Corporation Counsel Conlon December 16th and revised it on December 19th. It's entitled Request for Advice. The Bristol Planning, and this is from myself to Attorney Conlon. The Bristol Planning Commission, the Commission is seeking written advice from your office on its obligations under the city charter to allow public comment at its regular meetings. The Commission has been approached by a citizen claiming that under Section 49 of the city charter, the public has the right to be heard on any business proper to come before the Commission. The Commission has not in the past carried an agenda item specifically for public comment at its regular meetings. Public comment is taken on applications during public hearings, as required by law, for subdivision and on other development applications at the discretion of the chairman. Typically, other agenda items such as old and new business, staff report, etc. have not been open to public comment during regular meetings of the Commission. There has been limited public comment allowed in the past as an agenda item during specific special meetings, such as the recently completed 2015 Plan of Conservation and Development process. The Commission is obviously interested in balancing its obligations under the Charter, along with maintaining control of its meetings, meeting agendas, and conducting its business, while also upholding its responsibility to adhere to the statutory timeframes for development applications imposed by Section 8-7D of the Connecticut General Statutes. Among the questions, would the charter provision be satisfied with a general public comment agenda item for each regular meeting? Would any business proper to come before the Commission be defined as items on a specific regular meeting agenda, or encompass any item or any matter that could potentially come within the purview of the Commission? And finally, how much latitude does the Commission or its chairman have in setting standards and limits on public comment? It is requested that this information be provided for the January 25th, 2017 meeting of the Commission. In the interim, if you'd like to speak with Chairman Beats and/or staff to discuss this matter in greater detail, please contact my office to facilitate such a meeting.
Thank you.
You're welcome.
And in response to that, Attorney Lacey from the Assistant Corporate Counsel, about 4:30 today, sent in a memorandum to the Planning Commission, and I would like the Commission to vote on this so that it can be read into the record by Attorney Lacey. Any problems with that? No? Okay. Okay. Attorney Lacey, would you mind reading this into the record?
If I could, I do have copies, and perhaps with your permission, I could just summarize it.
Okay.
Because it is, I promised Mr. Flanagan I wouldn't drone on about the constitutional issues.
Attorney Lacey, everyone has a copy.
Oh, you all have copies?
Yes.
Okay, that's... Very good.
State your name.
Richard Lacey, Assistant Corporation Counsel.
Can you just bring the microphone down just a little?
I certainly can.
Thank you.
Mr. Chairman, I think that Mr. Flanagan's question to our office was excellent, and we were attempting to give you some guidance on how to handle Section 49 of the Charter. Just by way of background, to put it into context, there really is no constitutional right for a member of the public to speak to a local board or commission. There's a long line of cases that feel that in our Republican form of government, the right of the public to speak is unfettered, is not unfettered. You certainly have a situation where members of the public could, in effect, filibuster and, as Justice Sandra Day O'Connor said, grind the wheels of local government to a halt. However, in our charter, the Charter of the City of Bristol does recognize the right of an elector to speak to a board of commission on any proper question, proper business to come before the board. I would challenge anyone to define clearly what a proper question is, or a proper what is proper business to come before a board. In fact, courts have said, and the Supreme Court has said, that we're not going to get involved into what a local chair may allow a member of the public to speak about, because it's not capable of definition or enforcement. So I believe that a local board has very wide discretion on what could be heard in terms of what a member of the public may say. And certainly that right to be heard can be limited in terms of time. I've seen cases all the way from as low as 2 minutes to 5 minutes, but you certainly can impose rules limiting the amount of time a member of the public could speak. Our thought, and the collective thought of our office, is that any commission, any board could limit the subject matter of public comment to an agenda item, something the commission is going to take some action on. And we feel that that would satisfy the requirements of Section 49 of the Charter. That's not to say that should time allow, that you couldn't allow longer time, that you couldn't allow a member of the public to speak on virtually any topic. But you must remember that you've got a very clear statutory duty and a very important duty to move the business of the Planning Commission forward. And that really is your first duty. Now, as I understand how the agendas of the Planning Commission operate, public comment is built in pretty much to most of the work that you do. Certainly on an application, I think that Bristol does an excellent job allowing both the proponents and the opponents to speak. I've seen those go on way into the wee hours of the morning, and certainly everyone has an adequate opportunity to voice their opinions on an application. Because that is a statutory framework, that process should not change, and members of the public should not be allowed to comment outside that process. That would only lead to a potential appeal, because we have to preserve the record. Certainly when you're presenting studies or working on your plan of development, public comment is built into that process. It's built into the statute. So they have members of the public have an adequate opportunity to be heard, and a very ample opportunity to be heard when you're discussing that sort of work. So having said that, and at the risk of repeating myself, I think that the commission can set reasonable limits on what can be said and how long it can be said. How to do that is really up to you. I've spoken with Mr. Flanagan. He kind of favors, and might be very practical, a public participation element in your agenda. Our office is not mandating that or even suggesting that. I was surprised to find out from the clerk today that we have more than 90 boards, commissions, and committees. That was a surprise even to me.
That's a surprise.
And we certainly don't want to tell each committee what to do or how to set their agenda. I guess what we are saying is that if you're going to take action, and if there's an agenda item, that elector has a right to speak. How you do it is up to you. I can tell you that for maybe almost 2 decades, the way the city council handled it was they didn't really have a public participation component. An agenda item would come up, the city council was going to take action. People in the audience would raise their hand, the mayor would recognize them, and they would speak when that agenda item came up. That's perfectly acceptable. The council, by ordinance, has since changed that. When I started here, long time ago, public participation came at the end of the agenda. Now it comes, and I think more meaningfully, at the beginning of the agenda, because they're going to address items that may be acted upon by the council sometime that evening. You could do it either way. You certainly know your agendas, you know your board better than I do or anybody in my office does. I don't know how much public participation would come up on an agenda item. It would certainly be an option to recognize a member of the public and let them speak on the agenda item as it came up. Or you could, and it could be a more practical approach, to allow members of the public to speak on those items ahead of time. And again, I'd say, as the chair, for better or for worse, you have great latitude as to what people can speak about. But my suggestion would be conscious of your time limits, be conscious of your statutory responsibilities, and if time allows and you think it's relevant, you can certainly allow more time or even a broader number of topics. Now, I hope that helps. I hope that we're not being too vague.
No.
But if you walk away with anything, Section 49 of the Charter does say that an elector may speak on something proper to come before your commission.
Okay. Well, thank you. Knowing that, this is going to come up tonight, I talked to Mr. Flanagan, and I asked him to provide us with a motion that we can discuss tonight with everything basically that you stated tonight. So with that, I'd like Commissioner Ranger to read the motion, all right? And then we'll have a discussion on it, okay?
Mr. Chairman, I move that the Bristol Planning Commission direct staff to add the agenda item audience of citizens to its regular meeting agendas, starting with the February 22nd, 2017 regular meeting, in order to allow for public comment. The following guidelines for audience of citizens shall apply until further notice. The Bristol Planning Commission encourages citizens to express their views and concerns on agenda items during the audience of citizens. Because the Planning Commission's time is limited and its agenda can sometimes be extensive, the chairperson shall encourage brevity and consciousness in citizens' statements in order to allow other citizens to participate. The audience of citizens shall be limited during each regular meeting of the Planning Commission, 15 minutes. Each citizen shall be given 3 minutes, and the chairperson shall monitor the time used by each citizen. Comments will be limited to agenda items. For those of who are not able to offer comment during the audience of citizens, they are encouraged to submit comments in writing to the Planning Commission through the use of Land Use Office. Planning Commissioners are discouraged from using the audience of citizens to raise their own concerns during this portion of the agenda. Planning Commissioners should not offer comment on past, pending, or future development applications during the audience of citizens.
Okay, a motion was made. Is there a second?
Second.
Second. Further discussion. First of all, I'd like to thank Mr. Flanagan for writing up that motion for discussion tonight. Commissioners?
What was the time limit again? I think that's the time limit.
3 minutes.
3 per person.
Per person, 15 minutes time. That's 3 minutes per person.
So it's only 5 people.
Right. And that's on the agenda items only, right?
Exactly.
Okay.
Mr. Chairman?
Yes.
If I could ask a question.
Sure.
If I understood correctly, when an item that is up for a vote is presented, we normally allow people to respond?
Normally during public hearings, but so this is going to be added, this is going to be something different that we've never had in the past before.
So people will be able to speak about the items being presented before the items are actually presented, is that correct?
Yes. Yes. And just for the record, this is our new member tonight, Commissioner White, who, if I recall, spent 6 years on the zoning commission.
I lost track.
Welcome aboard.
Thank you.
And also for the record, Commissioner Terry Parker, the alternate, came in at 7:25 tonight. Okay.
Mr. Chairman, I have a question. Mr. Lacy, I think you said that if an item is scheduled for a hearing, and for instance, say a subdivision, residential subdivision, whatever, it's by statute, a public hearing is required, am I correct?
In most cases, yes.
Yeah. So if that would be the case, would that applicant or other people also be able to take advantage of this
No,
additional? No.
no, that would be against our advice because we want to preserve the record
Sure.
in case of an appeal.
Yeah.
And the statute sets forth a pretty clear mechanism as to how we handle applications. Proponent, opponents, and it goes back and forth. So we would caution against members of the public speaking about an application outside the public hearing process.
Mr. Lacy, do you think that's something that should be incorporated into these rules so that it's clear?
I don't have it in front of me, but I think Mr. Flanagan did put...
It just wasn't mentioned in
Yeah. Commissioner Posey, what I was more concerned with, rather than less concerned with the citizen getting up and offering comments on a pending application, whether the public hearing is open, it's been continued to another meeting. My real concern is the planning commissioners don't get drawn into a debate with someone outside of a public hearing. So, I mean, any citizen can come and make a comment, and if they want to If they offer comment outside the context of a public hearing on an application, it's their opinion, and they're certainly, it's their freedom of speech to be able to do that. But I just get concerned that the commissioners here don't engage with that person and create a record outside of the public hearing.
So I'm kind of confused. He's saying no, it sounds like you're saying
Yeah,
yes.
That's fair.
So can I do an example? So
Sure.
next month, we're going to go to a public hearing on application 399, and we shouldn't engage with any of our citizens or audience until that public hearing. If they want to come and talk about that application, that should not happen until that public hearing is held. So our agenda item for the citizens will be first or second on our agenda. Someone stands up and says, I want to say something about application, they have to wait till the public hearing, right?
Yes, and I think that could also be controlled by the chairman and in his discretion on how he wants to run the meeting.
And I think that Mr. Flanagan's correct in that. My advice to the chairman or to the chair would be that you would rule comments about a pending application as improper, and it wouldn't be proper business to come before the meeting at that point in time. Frankly, from my desk, I think it would be a built-in appeal if that sort of activity were to go on. Because if I were the applicant and someone was speaking against it, I wouldn't necessarily have an opportunity to rebut it, which I do in my public hearing. So, setting aside the legalese, is that really fair? No, I don't think so. So I think it's a good question.
It sounds like it's important enough to get written down somewhere.
Yeah, I think it's in my memo, but
So you're in essence saying people wait until an application is being heard before they speak, not before.
yes. Yes. And if I can just amplify some of Mr. Flanagan's remarks, there's no legal obligation for a commissioner to answer questions posed by the public. And it's very, very, it creates all kinds of problems. Sometimes the city council get engaged in a dialogue, but most of the time I think they follow our advice. They take in the information of the public, they thank them for the information, but it's not a question and answer session. And you as commissioners are not obligated, and it's probably not wise to engage in that dialogue.
Mr. Chairman, Lord knows this has been a hot button of mine. We all know that. I've had a few private discussions with Mr. Flanagan. Just afraid that we're still at this gray area that
Commissioner Howe, I think I have a solution. So in number 2, the last sentence starts, comments will be limited to agenda items. And if someone, I'm not making the motion, but just some suggested language, and if you all wanted to go along with that, you make that your motion. Comments will be limited to agenda items that are not development applications.
I think that's a good idea.
Could you repeat that one more time?
Sure. So number 2, the last sentence starts comments, and I would, if you all decided to do this, my suggested language to you would be, comments will be limited to agenda items that are not development applications, period.
Sorry, Bob. Agenda items?
Yes.
Wouldn't it be just anything that is not being covered?
I think agenda items makes it a little more narrower.
Okay.
My only question, Attorney Lacey, we were talking about public comments, but now public hearings. I'm trying to recall if we ever indicated that there's a time limit for people to come up and speak. on public hearings?
Mr. Chairman, it's a great question, and it's something that I was going to introduce to you folks as we move forward. The Zoning Commission has a list of public hearing rules, and I think that would be a very good procedure for you to implement, or whoever's chairing the next meeting. I can bring those rules with me, and they can be read into the record before the public hearing starts. And it talks about, those speaking for and against, and then a second round of questioning. It's very, as Commissioner White can attest to, it's a very logical process, and it lays down the ground rules for public hearings.
And is there a time limit on that per speaker?
There is not, but the Zoning Commission does have a 10 o'clock curfew.
We don't.
Not yet.
Not yet. Okay, so based on what Mr. Flanagan indicated, Commissioner Soares?
Did we mention agenda items? We mentioned agenda items that are not applications. Is that the way we put it?
Yes.
So
The
any
develop-
item on the agenda other than application is what we're talking about in this regard.
Yes.
Okay. What about something that's not an agenda item?
Oh, the way the motion reads, it should only be an agenda item. Is that correct, Mr. Flanagan?
Yes.
Is that right?
Yes.
Okay.
So Commissioner LaRanger, if you would add into the motion what Mr. Flanagan indicated on number 2 there. And just read that as an add-on.
Go ahead. I had a general question.
Go ahead.
Now, you're saying that somebody cannot go in public comment, and if it's not on the agenda, they had a gripe about something that concerns them, that they're not allowed to do that during public comment?
That's the way that Commissioner Wason, Attorney Wason.
What we're saying.
Yes, Commissioner. Something else would be at the discretion of the chair.
Okay. Mhm.
So if they wanted, if a member of the public who was an elector wanted to bring up something that wasn't on the agenda, may not even be planning related or directly planning related, could be allowed, but it would be at the discretion of the chair. See how the meeting's going, see what your time constraints are. But again, your primary business, your primary focus should be to correctly discharge your duties under the statute. And I think non-agenda items should really take a back seat to that duty. And I think I would speak to the chair and to the rest of the commissioners. Someday there will be an appeal. Someday Mr. Flanagan and I, we may not want to, but we're going to have to sit down and develop a record. The last thing I want to do is have my adversary say the Bristol Planning Commission allowed extraneous items about a pending application into a record in a public comment context. Because I just don't know how I would deal with that. Having prepared many records with Mr. Weiner, it's a very exacting process. We do not want to go searching for other comments made about pending applications. I really think that would be improper.
So in essence, we're really not much different than we're standing right now as far as the public comment. We really aren't, there is no, as the Planning Commission, and whether it's the conservation development question, we really are an important part of this town, and unless it's agenda, the public can't speak again.
That's not true, because there have been examples of someone coming in, not quite knowing what or where or who to see to seek advice, information, and we've allowed them to speak. Usually it's at the end of our meeting. But it doesn't mean everybody can come in here and just complain about everything and anything under the sun. That's not our responsibility.
I would also chime in, if I might, that we can always receive comments in writing in the office and pass them to the commission. So if something is an agenda item and it's something of great concern to a member of the public, they can send a letter to the chairman and we would include it in your packet. It wouldn't necessarily be on the agenda, but the information would be passed along to the commission.
Okay. Commissioner LaRange here, just add on to that modified number 2 there.
So I need to read the whole?
No.
No,
Okay.
just the
Just in addition to comments will be limited to agenda items that are not developmental application?
Just development applications. Yeah.
in nature, right? Okay, any further discussion? If none, all in favor? Aye.
Aye.
Opposed? Motion carries. Thank you. Thank you, Attorney Lacy. Next.
New business? There's none.
There's none.
Staff reports, we have the monthly subdivision status report.
Mr. Chairman, members of the commission, I just say that there has been no changes to the report. We duplicated it from last month. There were no changes to the report.
So then we move on to our last item, communications.
I don't see anything written here, but I'd like to bring up 2 things. One, congratulations to Commissioner Posey for being a permanent member of the Planning Commission as a regular. And also, at this time, I'd like to thank Paul Stradaman for all his years as a city engineer. I don't know if most of you know it, but Paul is going to be retiring next month after 32 years as being the engineer for the city of Bristol. And we all wish him well, and congratulations.
Thank you, Mr. Chairman.
You're welcome. Motion to adjourn?
So moved.
All in favor?
Aye.
Opposed, motion carries. We'll just settle down for 1 minute, and then we'll go into our special meeting on the Route 6 study.